So, very good evening, all the participants. Today
Good
we'll
evening, sir.
start, today we'll start with section 28. Section 28 talks of approval of committee of creditors for certain actions. We have already seen the duties of IRP. We have seen the duties of RP, but there are certain actions for which approval of the committee of creditors is required. So this section says that notwithstanding anything contained in any other law for the timing in force, the resolution personnel during the corporate insolvency resolution process shall not take any of the following actions without the prior approval of the committee of creditors. So the first question which arises here is, suppose the RP takes some actions without the prior approval of the COC, then what will happen to those actions? Virenji?
Yes, sir. Sir, that will not be that will be void, sir.
Yes, so it will be void. So it is written clearly that any actions which are taken without the approval of the COC shall be void. It is written in 28 subsection 4. So 28 subsection 4 says where any action under subsection 1 is taken by the RP without seeking the approval of the committee of creditors in the manner as required in this section, such action shall be void. Now, what are the actions which can be taken here? The first action is raise any interim finance in excess of the amount as may be decided by the committee of creditors in their meeting. So please explain this, Viren Pariharji. What is the meaning?
सर सर एक्चुअली अगर उसका प्रॉपर्टी का वैल्यू 2 टाइम से ज्यादा है तो उस कंडीशन में आपको उसका जरूरत नहीं है सीओसी अप्रूवल। और उससे नीचे है अगर प्रॉपर्टी का वैल्यू तो उसमें उसका सीओसी का
That
अप्रूवल
is
लेना है।
different provision, but here they are talking of the prior approval of COC. So COC may say that okay, up to 50 crores or up to 5 crores, you can raise the interim finance. But
ओके सर।
beyond that, you seek our prior approval. So this is the meaning. That is a different
ओके
section which you are
सर।
referring to.
ओके सर। राइट
What
सर।
different है? This is different. Here
ओके
they are saying that the COC is fixing the monetary limit for the RP.
ओके सर।
That okay, up to this point, you need not take our approval, but beyond this, you need to take our prior. So that it also means that for every interim finance, prior approval may not be needed. So that will depend upon the decision of the COC. Okay? So raise any interim finance in excess of the amount as may be decided by the committee of creditors in their meeting. So COC may decide that okay, let him raise on his own up to say 10 crores. Beyond 10 crores, he can seek approval. This is the meaning.
ओके सर।
Next is create any security interest over the assets of the corporate debtor. What is the meaning? इसका क्या मीनिंग है? Create
एनी एनी एडिशनल चार्ज फॉर
right. So suppose some of the asset of the corporate debtor are say unsecured and he wants to create a security interest. So in that case, prior approval of the COC is needed. Okay. This is second. Third point, change the capital structure of the corporate debtor, including by way of issuance of additional securities, creating a new class of securities, or buying back or redemption of issued securities in case the corporate debtor is a company. Now please explain this clause. मतलब क्या है इसका?
capital structure means that whatever the capital in CD having means debenture shares or whatever. So without approval, without COC approval, he cannot sell or buy
Right.
or
He cannot
any.
issue any additional securities.
Yes, sir.
He cannot create new class of securities. Even buying back or redemption cannot be done without the prior approval of COC.
COC.
ठीक है. Next, record any change in the ownership interest of the corporate debtor. What is the meaning? Record any change in the ownership interest of the corporate debtor. तो क्या मीनिंग है?
Any additional share mean dilute of ownership.
Right. So if ownership of the corporate debtor is changing, say some new person is entering,
Yes, sir.
so in that case, approval of the COC will be required. Okay? Suppose there is a major change in the shareholding pattern. So in that case, the approval of the COC will be required.
Okay.
ठीक है. So it is likely that during CIRP, ownership of the corporate debtor may exchange hands. The resolution professional is prohibited from recording any change in ownership of the corporate debtor without the prior approval of COC. Next point. Next point is give instructions to financial institutions maintaining accounts of the corporate debtor for a debit transaction from any such accounts in excess of the amount as may be decided by the committee of creditors in their meeting. Now, what is the meaning? Yes, Viren Pariyar Singh. What is the meaning? Basically, the meaning here is that the RP cannot give instructions to the banks or financial institutions which are maintaining accounts of the corporate debtor for effecting debit transactions. ठीक है?
Okay, sir.
From any such account in excess of the amount as may be decided by the committee of creditors in their meeting. ठीक है?
So limit they will
COC may
decide.
decide
Particular.
कि भाई you can effect debits up to this limit.
Yes, sir.
So, but beyond that, prior approval of COC is required. Because the account is being operated by the RP. Account is not being operated by the COC.
Yes.
है ना? तो
Yes,
ऐसा
sir.
नहीं बोल सकता भाई 10 करोड़ रुपए यहां से वहां ट्रांसफर कर दो. लिमिट COC लिमिट फिक्स कर देगी उसकी कि भाई
Yes, sir.
इससे ज्यादा अगर डेबिट ट्रांजेक्शन होगी तो देन यू हैव टू टेक अवर प्रायर अप्रूवल.
Yes, sir.
Undertake any related party transactions. Now, what is the meaning? Undertake any related party transaction. What is the meaning?
And it's a related party of CD.
Right.
And
So, if there is whether transactions can be done with the related party of the CD? The
so with
answer
the
is
approval of
yes.
C.
Yes,
With
but
the-
with
yes, sir.
the prior approval of
Prior approval.
COC.
Yes, sir.
So, if you are entering into transactions with a related party, then you cannot undertake those transactions without the prior approval of COC.
COC.
Amend any constitutional documents of the corporate debtor. What is the meaning?
Sir, article of association or memorandum of
Right.
association.
Or LLP agreement in case of
Okay, yes.
LLP. है ना?
Yes,
So, if any such amendment is required, then prior approval of COC is needed. So, basically, these are all major decisions for which
Yes, sir.
prior approval of COC is required. And in case he does something without taking prior approval, then such an action shall be void.
Void. Sir.
Delegate its authority to any other person because the power is given to the RP. And suppose he wants to delegate its authority, so he cannot do so without the prior approval of COC.
Sure.
ठीक है? So there is a general management rule that a delegatee cannot delegate. This rule applies here also, and the resolution professional is not allowed to delegate any of his functions, powers, or duties vested in him to any other person unless permitted by the COC. ठीक है?
The regulation number, sir?
ये section number है.
Okay, sir.
हाँ.
Okay.
This is also based on the fact that the tribunal and the committee of creditors has reposed faith and confidence in the abilities and competence of the RP and no one else. Thus, any delegation of authority must be subject to prior approval of the committee of creditors. Dispose of or permit the disposal of shares of any shareholder of the corporate debtor or their nominees to third parties. So, if any of the shareholder of the CD wants to dispose of the shares, so in that case also approval of the COC shall be required. Make any change in the management of the corporate debtor or its subsidiary. So if any change is required in the management of the corporate debtor, suppose KMP is changing. So for all these things, approval of the COC is required. The resolution professional cannot make any change in the management of the corporate debtor or any of its subsidiary without the prior approval of the committee of creditors. No management personnel can be hired or fired by the RP without the approval of the committee of creditors. The resolution professional is not expected to carry out change in the management of the corporate debtor unless it is absolutely necessary under the circumstances, for which he must seek the approval of the COC before making any change. Okay. Now, transfer rights or financial debts or operational debts under material contracts otherwise than in the ordinary course of business. So he cannot transfer rights or financial debts or operational debts under material contracts. Make changes in the appointment or terms of contract of such personnel as specified by the Committee of Creditors. Because by way of general powers, the RP can appoint professionals. But if he wants to change, if he wants to make changes in the appointment or terms of contract of such personnel as may be specified by the COC, he has to take their prior approval. Make changes in the appointment or terms of contract of statutory auditors or internal auditors of the corporate debtor. For all these actions, prior approval of COC is needed.
Required.
The resolution personnel shall convene a meeting of the COC and seek the vote of the creditors prior to taking any of the actions under subsection 1. And what is the percentage? No action under subsection 1 shall be approved by the Committee of Creditors unless approved by a vote of 66% of the voting share. Okay. Now, where any action under subsection 1 is taken by the RP without seeking the approval of COC in the manner as required in this section, such action shall be void. Okay. The committee of, now suppose he does something. The Committee of Creditors may report the actions of the RP under subsection 4 to the board for taking necessary action against him under this code. Suppose he does something without taking the prior approval. So it shall be void and COC may report the action of the RP to the board. Board means IBB. Okay. Now 29. 29 talks of preparation of the information memorandum. The resolution personnel shall prepare an information memorandum in such form and manner containing such relevant information as may be specified by the board. And where it is specified? It is specified in regulation number 36. Okay. For formulating a resolution plan. The resolution personnel shall provide to the resolution applicant access to all relevant information in physical and electronic, provided such resolution applicant undertakes to comply with the provisions of law. For the time being in force relating to confidentiality and insider trading, to protect any intellectual property of the corporate data it may have access to, and not to share relevant information with third parties unless clauses A and B of this subsection are complied. For the purpose of this section, relevant information means the information required by the resolution applicant to make the resolution plan for the corporate debtor, which shall include the financial position of the corporate debtor, all information related to disputes by or against the corporate debtor, and any other matter pertaining to the corporate debtor as may be specified. Now let us see regulation number 36, which talks of the details which are to be given in the resolution, this information memorandum. So this information memorandum is a document, something similar to a prospectus, which is shown to the prospective resolution applicants. So what it says? There is a time limit also within which this has to be prepared. So it says, subject to sub-regulation 4, the IRP shall submit the information memorandum in electronic form to each member of the committee on or before the 95th day from the insolvency commencement date. Okay. So there is a limit that he has to submit the information memorandum in electronic form to each member of the committee on or before the 95th day from the insolvency commencement date. The information memorandum shall highlight key selling propositions and contain all relevant information which serves as a comprehensive document. Let us see the purpose behind preparation of information memorandum. Actually, it is a pitch document to be shown to the prospective resolution applicants. So it shall highlight the key selling propositions and contain all relevant information which serves as a comprehensive document conveying significant information about the corporate data, including its operations, financial statements to the prospective resolution applicant, and shall contain the following details of the corporate data. क्या details आनी है? Assets and liabilities, including contingent liabilities, with such description as on the insolvency commencement date, as are generally necessary for ascertaining their values. Matlab, you have to give the details in such a manner that they can ascertain the values from the information memorandum. Book value नहीं देना खाली आपको, ठीक है. Explanation. Description includes the details such as the date of acquisition, cost of acquisition, remaining useful life, identification number, depreciation charge, book value, geographical coordinates of fixed assets, and any other relevant details. ठीक है. Suppose a car is there. अब कार के बारे में आप क्या क्या इंफॉर्मेशन दे दोगे भाई? On what date it was acquired, what was the cost of acquisition, what is the remaining useful life, if there is any identification number, what is the depreciation charge till date, book value, geographical coordinates, and any other relevant details. Okay? So all these details are to be given regarding assets and liabilities, including contingent liabilities. Okay? The latest annual financial statements. Next, audited financial statements of the corporate data for the last 2 financial years and provisional financial statement for the current financial year made up to a date not earlier than 14 days from the date of the application. ठीक है, तो ये आपको इंफॉर्मेशन देनी है. A list of creditors containing the names of creditors, the amount claimed by them, the amount of their claims admitted, and the security interest, if any, in respect of such claims. Particulars of a debt due from or to the corporate debtor with respect to related parties. So all this information is to be given. Details of guarantees that have been given in relation to the debts of the corporate debtor by other persons, specifying which of the guarantors is a related party. ठीक है. Names and addresses of the members or partners holding at least 1% stake in the corporate debtor along with the size of the stake. Details of all material litigation and an ongoing investigation or proceeding initiated by government and statutory authorities. The number of workers and employees and liabilities of the corporate debtor towards them. ठीक है. Company overview including snapshot of business performance, key contracts, key investment highlights, and other factors which bring out the value as a going concern over and above the assets of the corporate debtor, such as brought forward losses in the income tax returns, input credit of GST, key employees, key customers, supply chain linkages, utility connections, and other pre-existing facilities. Details of business evolution, how the business evolved, industry overview, and key growth drivers in case of a corporate debtor having book value of total assets exceeding 100 crore rupees as per the last available financial statements. ठीक है. Other information which the resolution professional deems relevant to the committee. A member of the committee may request the RP for further information, and the RP shall provide information to all members within a reasonable time if such information has a bearing on the resolution plan. ठीक है. The creditors shall provide to the resolution professional the latest financial statements and other relevant financial information of the corporate debtor available with them. The resolution professional shall share the information memorandum after receiving an undertaking from a member of the committee to the effect that such member or resolution applicant shall maintain confidentiality of the information and shall not use such information to cause an undue gain or undue loss to itself or any other person and comply with the requirements under subsection 2 of section 29. ठीक है, तो ये है सारा इसमें डिटेल्स regarding this information memorandum. Invitation for expression of interest. Let us see this also. What it says. The resolution professional shall publish brief particulars of the invitation for expression of interest in Form G of the Schedule 1 at the earliest not later than 60th day from the insolvency commencement date from interested and eligible prospective resolution applicants to submit resolution plans. तो सबसे पहले क्या करेंगे? They shall publish brief particulars of the invitation for expression of interest in Form G. ठीक है. So let us have a look at Form G also. एक बार Form G भी देख लेते हैं कि Form G क्या है. दिस इज फॉर्म जी, इन्विटेशन फॉर एक्सप्रेशन ऑफ इंटरेस्ट। तो ये डिटेल्स इसके अंदर जाती है। क्या क्या डिटेल है? ये name, address, URL, details of place where majority of fixed assets are located, installed capacity of main product services, quantity and value of main product services sold in last financial year, number of employees workmen. Further details including last available financial statements with schedules of 2 years, lists of creditors, relevant dates for subsequent events of the process are available at, वो वहां पर URL दे देंगे, ठीक है, एक वेबसाइट बना करके उसका लिंक दे देते हैं। Eligibility for resolution applicants under section 25(2)(h) of the code is available at last date for receipt of expression of interest, date of issue of provisional list of prospective resolution applicants, last date for submission of objections to provisional list, process email ID to submit expression of interest. ठीक है, so this is form G. Now this form G is to be published where? ये कहाँ publish करना है? The resolution professional shall publish form G in one English and one regional language newspaper with wide circulation at the location of the registered office and principal office, if any, of the corporate debtor and any other location where, in the opinion of the RP, the corporate debtor conducts material business operations. On the website, if any of the CD, on the website, if any designated by the board for the purpose, and in any other manner as may be decided by the committee. The form G in the schedule 1 shall state where the detailed invitation for expression of interest can be downloaded or obtained from as the case may be. Okay? And provide the last date for submission of expression of interest, which shall not be less than 15 days from the date of the issue of detailed invitation. ठीक है। अच्छा वीरेन परिहार जी,
Yes,
whether
sir.
this form G and information memorandum, whether they are same or they are different things?
It's a difference, sir.
Yes. What is, if you want to explain information memorandum, how you will explain information memorandum?
Sir, explain the information memorandum is a brief of information, sir.
Right.
Means, but in form G, they have to mention more things, detailed
Okay.
detailed information, sir.
नहीं,
Form
form
G.
G is detailed or information memorandum is detailed?
The information of memorandum is detailed, sir.
Right. Information memorandum is basically a pitch document, basically for prospective resolution applicants, which contains the details of assets and liabilities,
Yes, sir.
even contingent liabilities. So what are the pluses and minuses? So that the prospective resolution applicant can prepare a resolution plan based on that information memorandum.
Yes.
ठीक है ना? Now this expression of interest is the first step. Expression of interest actually it shall contain brief particulars of the invitation for expression of interest.
Yes.
So this is the first point, inviting expression of interest from interested and eligible prospective resolution applicants to submit resolution plans. Okay? This is published in paper on the website also of the CD of the board and as may be decided by the committee. Okay? So this shall give this shall state where the detailed invitation for expression of interest can be downloaded or obtained. Provide the last date for submission of expression of interest, which shall not be less than 15 days from the date of issue of the detailed invitation. Okay? And the detailed invitation referred to in sub-regulation 3 shall specify the criteria for prospective resolution applicants as approved by the committee in accordance with clause H of subsection 2 of section 25. Because the COC decides the criteria that what type of prospective resolution applicants they are looking for. State the ineligibility norms under section 29A to the extent applicable for prospective resolution applicants. Provide such basic information about the corporate debtor as may be required by a prospective resolution applicant for expression of interest. Not require payment of any fees or any non-refundable deposit for submission of expression of interest. So the question here is whether they can ask for refundable deposit. The answer is yes. Just to ensure seriousness, so they may require a refundable deposit for submission of expression of interest, but they cannot ask for any non-refundable deposit. Any modification in the invitation for expression of interest may be made in the manner as the initial invitation for expression of interest was made. Okay? Provided that such modification shall not be made more than once. So whether form G can be issued again?
Yes, sir.
Yes, it can be issued again,
Yes, sir.
but
It's for
modification shall
latest
not be made more than once.
once. Okay.
A prospective resolution applicant who meets the requirements of the invitation for expression of interest may submit expression of interest within the time specified in the invitation under clause B of subregulation 3. Expression of interest received after the time specified in the invitation shall be rejected. Okay. Now, what are the things to be included? An expression of interest shall be unconditional and be accompanied by an undertaking. First of all, he will give an undertaking that it meets the criteria specified by the committee under clause H of subsection 2 of section 25. Relevant records in evidence of meeting the criteria. Suppose the COC has specified under 25(2)H that okay, we are looking for prospective resolution applicants having turnover of say 1000 crores. So he will give evidence of meeting the criteria 1000 crores. Okay? Say by submission of balance sheets, etc. Then an undertaking by the prospective resolution applicant that it does not suffer from any ineligibility under 29A to the extent applicable. Relevant information and records to enable an assessment of ineligibility under clause C. Undertaking by the prospective resolution applicant that shall intimate the resolution professional forthwith if it becomes ineligible at any time during the CIRP process. An undertaking by the PRA that every information and records provided in expression of interest is true and correct, and discovery of any false information or record at any time will render the applicant ineligible to submit resolution plan, forfeit any refundable deposit, and attract penal action under the code. And an undertaking by the PRA to the effect that it shall maintain confidentiality of the information and shall not use such information to cause an undue gain or undue loss to itself or any other person, and comply with the requirements under subsection 2 of section 29. The resolution professional shall conduct due diligence based on the material on record in order to satisfy that the prospective resolution applicant complies with the provisions of clause H of subsection 2 of section 25, the applicable provisions of section 29A, and other requirements as specified in the invitation for expression of interest. RP may seek any additional clarification or additional information or document from the PRA. The resolution professional shall issue a provisional list of eligible prospective resolution applicants within 10 days of the last date for submission of expression of interest to the committee and to all prospective resolution applicants who submitted the expression of interest. पहले क्या करेगा ये? एक provisional list बनाएगा of eligible prospective resolution applicants. ठीक है? Now suppose somebody objects to it. कि भाई Y was not included. Any objection to inclusion or exclusion of a prospective resolution applicant in the provisional list referred to in sub-regulation 10 may be made with supporting documents within 5 days from the date of issue of the provisional list. On considering the objections received under sub-regulation 11, the resolution professional shall issue the final list of prospective resolution applicants within 10 days of the last date for receipt of objections to the committee. तो ये सारी timelines दे रखी है, ठीक है? कितने कितने दिन में क्या क्या काम करना है. Now, request for resolution plans. ठीक है? The resolution professional shall issue the information memorandum, evaluation matrix, and a request for resolution plans within 5 days of the date of issue of the provisional list under sub-regulation 10 of regulation 36A to every prospective resolution applicant in the provisional list and every prospective resolution applicant who has contested the decision of the resolution professional against its non-inclusion in the provisional list. Because if somebody's name is not included in the provisional list, he may or may not contest the decision. In case he has contested the decision, this information shall be given to him also. But if somebody has not contested, then this information memorandum, evaluation matrix, etc. will not be shared by him. Okay, with him. The request for resolution plans shall detail each step in the process and the manner and purposes of interaction between the RP and the prospective resolution applicant, along with corresponding timelines. The request for resolution plans shall allow prospective resolution applicants a minimum of 30 days to submit the resolution plans. ठीक है, ये RFRP जब हम देते हैं तो उसके बाद में भी अलाउ 30 days period to submit the resolution plan. The request for resolution plans shall not require any non-refundable deposit for submission of or along with the resolution plan. तो यहाँ पर भी क्या है, कोई non-refundable deposit नहीं ले सकते आप, you can take refundable deposit. ठीक है. The request for resolution plans shall require the resolution applicant in case its resolution plan is approved under subsection 4 of section 30 to provide a performance security. तो उसके क्या कहेंगे भाई, अगर आपका प्लान अप्रूव हो जाता है तो you will be required to provide a performance security within the time specified therein, and such performance security shall stand forfeited if the resolution applicant of such plan, after its approval by the adjudicating authority, fails to implement or contributes to the failure of implementation of that plan in accordance with the terms of the plan and its implementation schedule. For the purpose of this sub-regulation, performance security shall mean security of such nature, value, duration, and source as may be specified in the request for resolution plans with the approval of the committee, having regard to the nature of the resolution plan and business of the corporate debtor. ठीक है. Performance security may be specified in absolute terms such as guarantee from a bank or in relation to one or more variables. Any modification in the request for resolution plans or the evaluation matrix shall be deemed to be a fresh issue and shall be subject to timelines under sub-regulation 3, provided that such modification shall not be made more than once. ठीक है. The resolution personnel may, with the approval of the committee, extend the timeline for submission of resolution plans. ठीक है. So if he wants to extend the timeline for submission of resolution plan, he has to take the approval of the committee. If the resolution personnel does not receive a resolution plan in response to the request under this regulation, मान लीजिए कोई plan आया ही नहीं, he may, with the approval of the committee, issue request for resolution plan for sale of one or more of assets of the corporate debtor. ठीक है. The resolution personnel may, with the approval of the committee, reissue request for resolution plans if the resolution plans received in response to an earlier request are not satisfactory. आए तो सही plan, but ज़्यादा बढ़िया नहीं आए. Subject to the condition that the request is made to all prospective resolution applicants in the final list, provided that provisions of sub-regulation 3 shall not apply for submission of resolution plans under this sub-regulation.
सर
Yes.
सर 6A में ये लास्ट में ऐसा लिखा है कि वो तो उसमें उसके लिक्विडेशन के लिए जाएगा कि सेल ऑफ वन और मोर असेट ऑफ द
नहीं ना से ना, अभी तो रेजोल्यूशन प्लान की ही बात हो रही है.
अच्छा,
रेजोल्यूशन प्लान में ही सेल की बात कर रहा हूं.
ओके.
यहाँ लिक्विडेशन नहीं हो रहा.
अच्छा, उसमें ओके. तो अगर पार्ट प्रॉपर्टी के लिए रिजोल्यूशन आएगा तो पार्ट का एक्सेप्ट करेगा, ऐसे बोल रहे हैं सर?
हाँ बिल्कुल बिल्कुल.
ओके, ठीक है.
अब हम चलते हैं 29A पर. 29A टॉक्स ऑफ इनएलिजिबिलिटी. तो क्या क्या है 29A में? 29A में इट सेज अच्छा 29 तो हमने पूरा कर लिया था. 29A 29A बोलता है पर्सन्स नॉट एलिजिबल टू बी रेजोल्यूशन एप्लीकेंट. कौन कौन रेजोल्यूशन प्लान सबमिट नहीं कर सकता? ए पर्सन शैल नॉट बी एलिजिबल टू सबमिट ए रेजोल्यूशन प्लान if such person or any other person acting jointly or in concert with such person is an undischarged insolvent. ठीक है. अनडिस्चार्ज इंसॉल्वेंट कौन होता है? अनडिस्चार्ज इंसॉल्वेंट इज ए पर्सन अगेंस्ट whom insolvency proceedings have started but not yet culminated. Discharge order has not yet been issued. वो होता है अनडिस्चार्ज इंसॉल्वेंट. ठीक है. Second is a willful defaulter in accordance with the guidelines of the Reserve Bank of India issued under the Banking Regulation Act. ठीक है. At the time of submission of the resolution plan, हैज एन अकाउंट, किसका अकाउंट? जो आदमी
सबमिट कर रिजोल्यूशन,
सबमिट कर रहा है,
एप्लीकेंट।
ठीक है,
ओके।
या एनी अदर पर्सन एक्टिंग जॉइंटली और इन कंसर्ट, जो कॉमन इंटेंशन। एक्टिंग जॉइंटली और इन कंसर्ट मतलब पर्सन विद ए कॉमन इंटेंशन। या तो उसका अकाउंट होगा या अकाउंट होगा किसी सीडी का। सपोज मिस्टर एक्स वांट्स टू सबमिट ए रेजोल्यूशन प्लान, ठीक है, तो सी में कौन कौन से केसेस कवर होंगे? या तो सी का अपना अकाउंट होगा, या किसी कंपनी का अकाउंट होगा विच इज अंडर द मैनेजमेंट और कंट्रोल ऑफ सच पर्सन, ठीक है। सो एक सपोज देयर इज ए कंपनी एक्स वाई जेड लिमिटेड ऑफ विच एक्स इज द प्रमोटर और एक्स हैज कंट्रोल, इट इज अंडर द मैनेजमेंट और कंट्रोल or of whom such person is a promoter classified as NPA, and this account has been classified as NPA in accordance with guidelines of RBI or the guidelines of a financial sector regulator, and at least a period of 1 year has lapsed, ठीक है। एनपीए भी डिक्लेयर हो गया और 1 साल लैप्स भी हो गया फ्रॉम द डेट ऑफ सच क्लासिफिकेशन टिल द डेट ऑफ कमेंसमेंट ऑफ द सीआईआरपी प्रोसेस ऑफ द कॉर्पोरेट डेटा, ठीक है। तो उस केस में ऐसा आदमी प्लान सबमिट नहीं कर पाए, provided that the person shall be eligible to submit a resolution plan if such person makes payment of all overdue amounts, जितना भी overdue amount है उसका पेमेंट कर दो with interest and charges relating to NPA accounts before submission of resolution plans, ठीक है, तो भी आप प्लान सबमिट कर सकते, ठीक है। प्रोवाइडेड फर्दर दैट nothing in this clause shall apply to a resolution applicant where such applicant is a financial entity. Financial entity क्या है? Financial entity basically banks, financial institutions, alternative investment funds, mutual funds, etc. etc. ठीक है, डिटेल पूरा दिया गया है फाइनेंशियल एंटिटी की डेफिनेशन, and is not a related party to the corporate debtor. For the purpose of this proviso, the expression related party shall not include a financial entity regulated by a financial sector regulator if it is a financial creditor of the corporate debtor and is a related party of the corporate debtor solely on account of conversion or substitution of debt into equity shares or instruments convertible into equity shares or prior to the insolvency commencement date. For the purpose of this clause, where a resolution applicant has an account or an account of a corporate debtor under the management or control of such person or of whom such person is a promoter, and such account was acquired pursuant to a prior resolution plan approved under this code, then the provisions of this clause shall not apply to such resolution applicant for a period of 3 years from the date of approval of such resolution plan. तो एक बार वीरेन परिहार जी इसका मतलब समझाइए मेरे को, एक्सप्लेनेशन 2 का, व्हाट इज द मीनिंग? हाँ जी।
सर ऑलरेडी इसके अगर मान लो उसने रिजोल्यूशन एप्लीक पहले उसके नाम पे अप्रूव हो गया रिजोल्यूशन, और लास्ट 3 ईयर में और उसने फुलफिल नहीं हुआ।
नहीं, इसका मतलब ये है कि ये जो रेजोल्यूशन एप्लीकेंट, लेट अस एज्यूम मिस्टर एक्स इज ए प्रोस्पेक्टिव रेजोल्यूशन एप्लीकेंट, ठीक है, वो
अच्छा।
रेजोल्यूशन
हाँ।
प्लान देना चाहता है।
हाँ,
उसने किसी कंपनी को पहले भी खरीदा था।
अच्छा
भाई,
अच्छा।
जो भी प्रोस्पेक्टिव रेजोल्यूशन
हाँ।
एप्लीकेंट बनता है वो एक्वायर करता है ना कंपनी को।
यस सर।
सपोज ही हैज एक्वायर्ड ए कंपनी इन द पास्ट ऑल्सो, वो प्लान अप्रूव हो गया था जो किसी और दूसरी कंपनी का,
जी सर।
ठीक है। तो जब उसने कंपनी को एक्वायर किया होगा, उसके एसेट्स एंड लायबिलिटीज एक्वायर किए होंगे,
यस सर।
उसमें एनपीए अकाउंट्स भी आए होंगे। भाई, जो भी कंपनी
यस,
आप
हाँ यस
खरीदते
सर।
हो उसमें तो एनपीए अकाउंट्स आते ही है ना।
हाँ जी सर।
तो उन एनपीए अकाउंट्स को सही करने के लिए इसने 3 साल का पीरियड दिया, उसमें 1 साल में नहीं हो पाएगा ना,
जी सर।
ये है। तो वो ये कहता है, देन द प्रोविजंस ऑफ दिस क्लॉज shall not apply to such resolution applicant for a period of 3 years from the date of approval of such resolution plan, ठीक है। सपोज ए कंपनी हैज बीन एक्वायर्ड बाय द प्रोस्पेक्टिव रेजोल्यूशन एप्लीकेंट pursuant to an approved resolution plan earlier, ठीक है। सो ही माइट हैव एक्वायर्ड द एनपीए अकाउंट्स आल्सो, है ना।
यस सर।
तो फॉर दोज एनपीए अकाउंट्स टू बी रिस्ट्रक्चर्ड ए पीरियड ऑफ 3 years इज अलाउड इंस्टेड ऑफ 1 year। नॉर्मल 1 year का
ओके
पीरियड है
सर।
ना,
जी सर।
यहां पर क्या है 3 years। और 3 years कब से लेने हैं आपको? डेट ऑफ अप्रूवल ऑफ सच रेजोल्यूशन, ठीक है, क्लियर है।
Clear, sir.
Next, has been convicted for any offense punishable with imprisonment for 2 years or more under any act specified under the 12th schedule. अब 12th शेड्यूल में जो एक्ट्स हैं उसके लिए कितना है, 2 years और मोर. और 12th शेड्यूल क्या है, दिस इज द 12th शेड्यूल. ठीक है, ये पूरा हमारा 12th शेड्यूल है, बेसिकली इकोनॉमिक लॉज इसके अंदर. और फॉर 7 years और मोर अंडर एनी लॉ फॉर द टाइमिंग इन फोर्स. जो इसमें नहीं है वो फिर उसके लिए 7 years और मोर. ठीक है, मान लो आईपीसी में कुछ हो गया. प्रोवाइडेड दैट दिस क्लॉज शेल नॉट अप्लाई टू ए पर्सन आफ्टर द एक्सपायरी ऑफ ए पीरियड ऑफ 2 years फ्रॉम द डेट ऑफ हिज रिलीज फ्रॉम इम्प्रिजनमेंट. मतलब ये उसको जेल हो गई, ठीक है, 2 साल हो गए जेल से छूटे हुए, तो फिर वो दोबारा रेजोल्यूशन एप्लीकेंट बन सकता है. ठीक है. प्रोवाइडेड फर्दर दैट दिस क्लॉज शेल नॉट अप्लाई इन रिलेशन टू ए कनेक्टेड पर्सन रेफर टू इन क्लॉज 3 ऑफ एक्सप्लेनेशन 1. तो कनेक्टेड पर्सन पर ये क्लॉज अप्लाई नहीं हो. ठीक है, कनेक्टेड पर्सन का मतलब हम देख लेते हैं, अगला भी पढ़ लेते हैं, फिर दोनों के साथ में कनेक्टेड पर्सन का मतलब पढ़ लेंगे, कोई डी और ई में ही है ये. नेक्स्ट इज डिसक्वालिफाइड टू एक्ट एज ए डायरेक्टर. So if any person is disqualified to act as a director, he cannot become a resolution applicant, provided that this clause shall not apply in relation to a connected person referred to in clause 3 of explanation 1. तो एक बार clause 3 पढ़ लेते हैं explanation 1 का. What is clause 3? ये explanation 1 पढ़ते हैं, क्या बोलता है. For the purpose of this clause, the expression connected person means any person who is the promoter or in the management or control of the resolution applicant. ठीक है, ये वाला पॉइंट क्लियर है. एनी पर्सन हु इज द प्रोमोटर और इन द मैनेजमेंट और कंट्रोल ऑफ द रेजोल्यूशन एप्लीकेंट, और एनी पर्सन हु शैल बी द प्रोमोटर. तो एक तो एग्जिस्टिंग प्रोमोटर और दूसरे जो प्रोस्पेक्टिव प्रोमोटर्स होंगे. मान लीजिए आप एक कंपनी को एक्वायर करना चाहते हो, तो आप उस कंपनी में प्रोमोटर कौन होगा वो देना पड़ता है. इन द रेजोल्यूशन प्लान यू हैव टू गिव दैट दिस पर्सन शैल बी द प्रोमोटर, है ना. तो ऑल दीज पर्सन शैल बी इंक्लूडेड इन द डेफिनेशन ऑफ कनेक्टेड पर्सन. ठीक है. नेक्स्ट इज होल्डिंग कंपनी, सब्सिडरी कंपनी, एसोसिएट कंपनी और रिलेटेड पार्टी ऑफ ए पर्सन रेफर टू इन क्लॉज 1 and 2. मतलब ये कि यू आर ए रेजोल्यूशन एप्लीकेंट, यू आर मिस्टर एक्स, यू आर सबमिटिंग ए रेजोल्यूशन प्लान. ठीक है. सो देर इज ए कंपनी ऑफ विच यू आर द प्रोमोटर, सो दैट कंपनी इज द कनेक्टेड पर्सन. कनेक्टेड पर्सन हो गया ना, एनी पर्सन. पर्सन इंक्लूड्स कंपनी, एचयूएफ, ट्रस्ट, पार्टनरशिप फॉर्म, एवरीथिंग, है ना, इन इवन रेजिडेंट आउटसाइड इंडिया. ठीक है. तो प्रेजेंट प्रोमोटर, प्रोस्पेक्टिव प्रोमोटर, लेकिन होल्डिंग कंपनी, सब्सिडरी कंपनी, एसोसिएट कंपनी और रिलेटेड पार्टी ऑफ ए पर्सन रेफर टू इन क्लॉजेस 1 and 2. तो इस पर ये क्लॉज अप्लाई नहीं होगा, जो थर्ड वाला है, होल्डिंग कंपनी, सब्सिडरी कंपनी, एसोसिएट कंपनी और रिलेटेड पार्टी ऑफ ए पर्सन रेफर टू इन क्लॉज 1 and 2. ठीक है. कौन सा क्लॉज अप्लाई नहीं होगा, एक तो इम्प्रिजनमेंट वाला और डिसक्वालिफिकेशन टू एक्ट एज डायरेक्टर. ठीक है. Is prohibited by SEBI from trading in securities or accessing the securities market. But suppose you have been issued a show cause notice by SEBI, whether you can submit the resolution plan?
Yes, sir.
Yes. The bar is once you have been prohibited. एक prohibitory order होना चाहिए from SEBI that you are hereby barred from trading in securities or you are hereby barred from accessing the securities market. Has been a promoter or in the management or control of a corporate debtor in which PUFE transaction took place and in respect of which an order has been made by the adjudicating authority under this code. ठीक है. मतलब ये कि you have been the promoter or in the management or control of a corporate debtor in which some avoidance transactions took place. ठीक है. And the order also has been made by the adjudicating authority. Suppose application has been filed for avoidance transactions, you can still become a resolution applicant, provided that this clause shall not apply if a preferential transaction undervalued transaction, extortionate transaction, or fraudulent transaction has taken place prior to the acquisition of the corporate data by the resolution applicant pursuant to a resolution plan approved under this code or pursuant to a scheme or plan approved by a financial sector regulator or a court, and such resolution applicant has not otherwise contributed to the transaction. तो एक बार मतलब समझा सकते हैं इसका वीरेन परियार जी?
नहीं आया समझ में सर इसका।
हाँ, इसका मतलब ये है कि देखिए, यू आर इन द हैबिट ऑफ एक्वायरिंग कंपनीज, ठीक है? नाउ यू आर ए
ओके।
रेजोल्यूशन एप्लीकेंट। आपने एक कंपनी एक्वायर किया था पहले भी, जिसमें कोई पीयूएफई ट्रांजैक्शन हुआ था, लेकिन
ओके
उसका रेजोल्यूशन प्लान अप्रूव हो गया, ठीक है?
ओके
और
ठीक है सर।
आपका कोई हाथ नहीं था उस पीयूएफई ट्रांजैक्शन में,
ठीक है।
मतलब आप उस ट्रांजैक्शन में इन्वॉल्व नहीं थे,
ठीक है सर।
ये मतलब है। तो उस केस में ये अप्लाई नहीं होगा। भाई ऐसा होता है ना कि जो रेजोल्यूशन एप्लीकेंट होते हैं वो तो कंपनियां खरीदते रहते हैं बहुत सारी। अगर मान लो उसने पहले कोई कंपनी खरीदी थी, है ना,
हम्म,
जिसका रेजोल्यूशन प्लान पास हो गया था,
जी सर।
उसमें पीयूएफई ट्रांजैक्शन हो ही पड़ी थी, लेकिन उन पीयूएफई ट्रांजैक्शन में इसका कोई हाथ नहीं था, ये जो रेजोल्यूशन एप्लीकेंट
ठीक है।
है ना, ही हैज नॉट अदरवाइज कंट्रीब्यूटेड टू द पीयूएफई ट्रांजैक्शन,
ओके सर।
ठीक है? नेक्स्ट इज हैज एक्सिक्यूटेड ए गारंटी इन फेवर ऑफ ए क्रेडिटर in respect of a corporate debtor against which an application for insolvency resolution made by such creditor has been admitted under this code, and such guarantee has been invoked by the creditor and remains unpaid in full or part. मतलब क्या? यू आर मिस्टर एक्स, ठीक है, एंड देयर इज ए कंपनी एक्स वाई जेड लिमिटेड फॉर विच यू हैव गिवन द गारंटी, ठीक है? एक्स वाई जेड कुड नॉट पे, so your guarantee given by you, Mr. X, has been invoked and it remains unpaid. ठीक है? And such creditor to whom you had given the guarantee, suppose XYZ took a loan from PNB, ठीक है, to which you stood as a guarantor, Mr. X. You are Mr. X, you stood a guarantor. You gave a guarantee to PNB. Company could not repay the loan. There was a default. And then PNB invoked the bank guarantee. ठीक है? And you could not pay the bank guarantee. It remains unpaid. Then PNB initiated the CIRP and such application has been admitted. Then you cannot become a resolution applicant. This is the meaning. Clear है?
ओके क्लियर है सर।
है ना? ये मतलब है।
जी सर।
चंद्रशेखर जी, you are there?
Good evening, sir. Yes, I am there, sir.
Good evening. Can you explain this clause once again, what I have explained?
Sir, I could not hear you, sir, because there was an urgent call. But I was going through the 29A regarding the eligibility only. This
Okay.
clause, sir, I'm unable to, sir.
Okay. So should I explain it to you again?
Sir, I'll go through, sir. Kindly continue, sir.
Okay. Next is subject to any disability corresponding to clauses A to H under any law in a jurisdiction outside India. अभी नाउ वी आर इन क्लॉज आई, वो बोलता है ए टू एच में कोई भी इनएलिजिबिलिटी अंडर एनी लॉ इन जुरिस्डिक्शन आउटसाइड इंडिया, जैसे सपोज कन्विक्शन इज आउटसाइड इंडिया, सपोज इज डिबार्ड फ्रॉम बाय सिक्योरिटीज एक्सचेंज कमीशन, जैसे यहाँ पर सेबी, वहां सिक्योरिटीज एक्सचेंज कमीशन है। इसी तरह से कोई पीओएफई ट्रांजेक्शन बाहर हुई है, तो ये कोई भी इनएलिजिबिलिटी अगर जुरिस्डिक्शन आउटसाइड इंडिया में हुई है तो भी फिर वो जो है रेजोल्यूशन एप्लीकेंट नहीं बन सकता, ठीक है? और हैज ए कनेक्टेड पर्सन नॉट एलिजिबल अंडर क्लॉजेस ए टू आई, कनेक्टेड पर्सन भी नहीं हो सकता। कनेक्टेड पर्सन का डेफिनेशन हमने पढ़ लिया। कनेक्टेड पर्सन में कौन कौन है? प्रेजेंट प्रोमोटर, प्रोस्पेक्टिव प्रोमोटर, या होल्डिंग सब्सिडरी एसोसिएट कंपनी और रिलेटेड पार्टी, ठीक है ना? तो ये सारे लोग रेजोल्यूशन एप्लीकेंट नहीं बन सकते, ठीक है भाई? बेसिकली वो चाहते हैं कि जो रेजोल्यूशन एप्लीकेंट है वो साफ सुथरा आदमी हो। मान लो वो जेल में ही रहा है ना, तो उसको नहीं बनने देंगे। विलफुल डिफॉल्टर है, अनडिस्चार्ज इंसॉल्वेंट है, उसका खुद का अकाउंट एनपीए चल रहा है ना, या किसी कंपनी में जो जिसमें वो प्रमोटर है उसका अकाउंट एनपीए चल रहा है, या पीयूएफई ट्रांजेक्शन हुई थी उसमें उसकी इन्वॉल्वमेंट थी, तो ऐसे आदमी को तो रेजोल्यूशन एप्लीकेंट नहीं बनने देंगे ना वो, ये बात है। ठीक है ना, ये है कहा। Provided further that the expression related party shall not include a financial entity regulated by a financial sector regulator if it is a financial creditor of the corporate debtor and is a related party of the corporate debtor solely on account of conversion or substitution of debt into equity shares. फिर ये मतलब दिया हुआ है फाइनेंशियल एंटिटी का, बेसिकली शेड्यूल्ड बैंक, फॉरेन सेंट्रल बैंक, इन्वेस्टमेंट व्हीकल, रजिस्टर्ड फॉरेन इंस्टीट्यूशनल इन्वेस्टर, रजिस्टर्ड फॉरेन पोर्टफोलियो इन्वेस्टर वगैरह वगैरह। ठीक है, ये है 29A। नाउ नेक्स्ट इज सबमिशन ऑफ रेजोल्यूशन प्लान्स, सेक्शन 30। अब सेक्शन 30 क्या बोलता है? सेक्शन 30 ये बोलता है कि भाई ए रेजोल्यूशन एप्लीकेंट में सबमिट ए रेजोल्यूशन प्लान along with an affidavit stating that he is eligible under 29A to the resolution professional prepared on the basis of information memorandum. ठीक है, the resolution professional shall examine each resolution plan received by him to confirm that each resolution plan provides for the payment of insolvency resolution process cost in a manner specified by the board in priority to the payment of other debts of the corporate debtor. तो सबसे पहले तो इंसॉल्वेंसी रेजोल्यूशन प्रोसेस कॉस्ट की पेमेंट करनी है। ठीक है, अब इंसॉल्वेंसी रेजोल्यूशन प्रोसेस कॉस्ट में क्या क्या आता है ये हमने पढ़ा हुआ
ये सर पढ़ा हुआ
है ना, क्या क्या आता है
ये सर।
उसमें?
सर उसमें आरपी का फी आता है, और जो उस रेजोल्यूशन प्रोसेस के टाइम जो भी आपने प्रोफेशनल हायर किया है उसकी कॉस्ट आता है, और वो उसमें जो लेबर आता है,
ये सेक्शन
इंटरिम
5
फाइनेंस।
सबसेक्शन 13 amount of any interim finance and the costs incurred in raising such finance, fees payable to any person acting as RP, any cost incurred by the RP in running the business of the corporate debtor as a going concern। तो जो भी कॉस्ट इनकर होगी इन रनिंग द बिजनेस ऑफ द कॉर्पोरेट डेटर एज ए गोइंग कंसर्न सारी इसके अंदर आ जाएगी। ठीक है, सपोज ए कोल सप्लायर इज देयर, अब उससे आप सप्लाई ले रहे हो तो वो कहाँ, यहां पर कवर हो जाएगी। ठीक है, any cost incurred at the expense of the government to facilitate the insolvency resolution process and any other cost as may be specified by the board। ठीक है, तो ये सारी आपकी इंसॉल्वेंसी रेजोल्यूशन प्रोसेस कॉस्ट में कवर होगी। सबसे पहले इसकी पेमेंट ही करनी है। उसके बाद में प्रोवाइड फॉर द पेमेंट ऑफ डेट्स ऑफ ऑपरेशनल क्रेडिटर्स। अब आप ये देखो यहां पर ना क्या हो रहा है कि पेमेंट नहीं हो रही, अभी प्रोविजन कर रहा है वो सारा। ठीक है, बिकॉज ही इज सबमिटिंग ए रेजोल्यूशन प्लान। तो रेजोल्यूशन प्लान ऐसा होना चाहिए कि वो ये बताएगा कि भैया सबसे पहले तो इंसॉल्वेंसी रेजोल्यूशन प्रोसेस कॉस्ट की पेमेंट कैसे करेगा। ठीक है, सेकंड क्या है, सेकंड में ये है कि जो प्रोवाइड फॉर द पेमेंट ऑफ डेट्स ऑफ ऑपरेशनल क्रेडिटर्स in such manner as may be specified by the board, which shall not be less than the amount to be paid to such creditors in the event of a liquidation of the corporate debtor under section 53। भाई देखिए ऐसा है, ऑपरेशनल क्रेडिटर्स दे डिड नॉट फाइंड प्लेस इन द सीओसी। ठीक है, सीओसी में तो जगह नहीं मिली इनको। सीओसी में कौन जाता है?
फाइनेंशियल क्रेडिटर,
सारे फाइनेंशियल क्रेडिटर्स,
एक्सक्लूडिंग रिलेटेड पार्टी।
राइट, सो अनरिलेटेड फाइनेंशियल क्रेडिटर्स।
यस सर।
ठीक है, whether operational creditors can also be invited to the meetings of the COC
Yes sir.
in
If
what
they are
which situation?
if they are having the more than 10% of,
Yes, not less than 10%. The word used is not less than 10%.
not less
Even if
than.
it is exactly 10%, they will be invited. One representative will be invited.
Yes.
ठीक है, but they cannot participate, they cannot vote, है ना? There is no
Yes,
right
sir.
of representation or voting to operational creditors. They will be just invited. तो इसके लिए इनको पेमेंट करना है, कितना पेमेंट करना है? The amount to be paid to such creditors in the event of a liquidation। तो जितना लिक्विडेशन में पेमेंट होता उतना कम से कम रेजोल्यूशन प्लान में इट हैज टू बी इंश्योर्ड दैट दे आर गेटिंग एट लीस्ट दिस मच वैल्यू, और the amount that would have been paid to such creditors if the amount to be distributed under the resolution plan had been distributed in accordance with the order of priority in subsection 1 of section 53। Acha, now you are a resolution professional. So how you will ensure this payment, that the amount to be paid to such creditors in the event of liquidation of the corporate data? Suppose I am a resolution applicant, okay, and I am saying that I will be paying OCs, OCs rupees, say a haircut. I am giving a haircut of say 60%. So how you will ensure that this provision is complied with? आप कैसे comply करोगे? आप कैसे ensure करोगे कि this provision has been complied? आपको कैसे पता चलेगा कि liquidation value दे रहा है कि नहीं दे रहा?
तो पहले वैल्यूएशन रिपोर्ट लेंगे हम उसका।
Right. So actually, within 7 days and maximum within 47 days, the RP has to appoint two registered valuers, which
Yes,
will
sir.
be giving him the fair value and liquidation value.
लिक्विडेशन वाले।
तो उससे उसको लिक्विडेशन वैल्यू का पता चल गया आरपी
Yes.
को। अब
हाँ।
आरपी वेदर ही विल डिस्क्लोज दिस लिक्विडेशन वैल्यू टू द रेजोल्यूशन एप्लीकेंट, उसको बताएगा या नहीं बताएगा?
नो सर।
उसको नहीं बताएगा, बिल्कुल ठीक है,
Yes.
क्योंकि वो अपने आप चेक करेगा कि भैया इसने इतना कम से कम अमाउंट उसको दे रहा है कि नहीं दे रहा ऑपरेशनल क्रेडिटर्स। ठीक है, वो उसके यार्डस्टिक हो गई उसके लिए, है ना, द अमाउंट टू बी पेड टू सच। और अगर ऐसा इफ ही इज नॉट गिविंग दिस मच अमाउंट देन हिज प्लान विल बी रिजेक्टेड। ठीक है, whichever is higher, and provides for the payment of debts of financial creditors who do not vote in favor of the resolution plan, because any resolution plan can be approved with 66% majority. और मान लीजिए, because then there may be some financial creditors who are not voting in favor of the resolution plan, so at least liquidation value should be payable to them, उतना उनको भी कम से कम मिल जाना चाहिए, रेजोल्यूशन प्लान में इतना प्रोविजन होना चाहिए। ठीक है, for the removal of doubts, it is hereby clarified that distribution in accordance with the provisions of this clause shall be fair and equitable to such creditors. ठीक है, for the purpose of this clause, it is hereby declared, ये फिर intervening period का कि भाई ये बाद में प्रोविजन आए थे ना, तो उन्होंने कहा था कि अगर रेजोल्यूशन प्लान अप्रूव नहीं हुआ या रिजेक्ट हो गया तो उसमें भी ये चीज आपको इंश्योर कर लेनी है। ठीक है, नेक्स्ट इज प्रोवाइड्स फॉर द मैनेजमेंट ऑफ द अफेयर्स ऑफ द कॉर्पोरेट डेटार आफ्टर अप्रूवल ऑफ द रेजोल्यूशन प्लान। ठीक है, मतलब ये कि जब प्लान अप्रूव हो जाएगा तो उसके बाद उसका मैनेजमेंट कौन करेगा, ये उसकी बात कर, क्योंकि जो सीडी है वो तो निकल जाएगा वहां से,
Yes, sir.
जो बोर्ड ऑफ डायरेक्टर्स है वो तो चेंज हो जाएंगे ना, उनकी पावर तो सस्पेंड हो चुकी है, अब तो नया रेजोल्यूशन एप्लीकेंट आ गया। तो इसमें भी आप 29A भी देखोगे यहाँ पर, है ना, कि 29A में कोई इनएलिजिबल तो नहीं है भाई। यहाँ पर देख, ये मैनेजमेंट ये कह देगा जी उसमें मिस्टर वाई विल बी KMP। अब हमें ये देख लेना है कि वाई जो है वो इनएलिजिबल तो नहीं है। ठीक है ना, देन द इम्प्लीमेंटेशन एंड सुपरविजन ऑफ द रेजोल्यूशन प्लान does not contravene any of the provisions of the law for the time being in force and conforms to such other requirements as may be specified by the board. ठीक है, for the purpose of clause E, if any approval of shareholders is required under the Companies Act or any other law for the time being in force for the implementation of actions under the resolution plan, such approval shall be deemed to have been given, and it shall not be a contravention of that act or law. The resolution professional shall present to the committee of creditors for its approval such resolution plans which conform to the conditions referred to in subsection 2. ठीक है, वो सारी conditions अगर comply with करता है तो ही वो plans COC के सामने पेश करेगा। ठीक है, the committee of creditors may approve a resolution plan by a vote of not less than 66% of the voting share of the financial creditors after considering its feasibility and viability. ठीक है, तो परसेंटेज कितना है, नॉट लेस देन 66%, and they will consider the feasibility and viability also. The manner of distribution proposed, which may take into account the order of priority amongst creditors as laid down in subsection 1 of section 53, including the priority and value of the security interest of a secured creditor and such other requirements as may be specified by the board. ठीक है, provided that the committee of creditors shall not approve a resolution plan submitted before the commencement of the IBC Amendment Ordinance 2017, where the resolution applicant is ineligible under 29A and may require the resolution professional to invite a fresh resolution plan where no other resolution plan is available. क्योंकि 29A भी बाद में आया था, तो वो ये कह रहा है कि भाई अगर जो रेजोल्यूशन प्लान पहले आ चुके हैं, बाद में 29A आ गया, तो देख लेना पड़ेगा 29A भी कंप्लाई विद हो रहा है कि नहीं हो रहा, ठीक है। और मान
अच्छा।
लीजिए एक ही रेजोल्यूशन एप्लीकेंट आया, वो इनएलिजिबल है 29A में, कोई दूसरा रेजोल्यूशन प्लान आया नहीं, तो उसको कहेंगे भाई दोबारा रेजोल्यूशन प्लान मंगवाइए, ठीक है, फ्रेश रेजोल्यूशन। Provided further that where the resolution applicant referred to in the first proviso is ineligible under clause C of 29A, ठीक है। क्लॉज सी क्या है? एनपीए अकाउंट्स, ठीक है। हैविंग रिमेन्ड सो 1 year, the resolution applicant shall be allowed by the committee of creditors such period not exceeding 30 days to make payment of overdue amounts। तो वो कह रहा है अगर सी वाली एलिजिबिलिटी है 29A सी वाली, तो उसमें आप 30 days के अंदर पेमेंट कर दीजिए, देन यू बिकम एलिजिबल। Provided also that nothing in the second proviso shall be construed as extension of the period for the purpose of proviso to subsection 3 of section 12, and the CIRP shall be completed within the period specified in that subsection, ठीक। The resolution applicant may attend the meeting of the committee of creditors in which the resolution plan of the applicant is considered, ठीक है। तो जिस सीओसी मीटिंग में उसका प्लान कंसिडर हो रहा है, वो वाली मीटिंग वो रेजोल्यूशन एप्लीकेंट अटेंड कर सकता है, ठीक है। प्रोवाइडेड दैट द रेजोल्यूशन एप्लीकेंट शैल नॉट हैव ए राइट टू वोट एट द मीटिंग ऑफ द कमिटी ऑफ क्रेडिटर्स अनलेस सच रेजोल्यूशन एप्लीकेंट इज आल्सो ए फाइनेंशियल क्रेडिटर। लेकिन अगर वो रेजोल्यूशन एप्लीकेंट फाइनेंशियल क्रेडिटर भी है तो वो वोट कर पाएगा, अदरवाइज नहीं, ठीक है। द रेजोल्यूशन पर्सनल शैल सबमिट द रेजोल्यूशन प्लान एज अप्रूव्ड by the committee of creditors to the adjudicating authority, ठीक है। नाउ 31 बोलता है अप्रूवल ऑफ रेजोल्यूशन प्लान। इफ द एडजुडिकेटिंग अथॉरिटी इज सेटिस्फाइड दैट द रेजोल्यूशन प्लान एज अप्रूव्ड बाय द कमिटी ऑफ क्रेडिटर्स अंडर सबसेक्शन 4 ऑफ सेक्शन 30 meets the requirements as referred to in subsection 2 of section 30, ठीक है, it shall by order approve the resolution plan। सबसे पहले किसने देखा? आरपी ने देख लिया। आरपी के बाद किसने देखा? सीओसी ने।
COC।
सीओसी के बाद एडजुडिकेटिंग अथॉरिटी,
Right.
ठीक है। तो वो फिर अप्रूव कर देगी, विच शैल बी बाइंडिंग ऑन द कॉर्पोरेट डेटर एंड इट्स एम्प्लॉइज, मेंबर्स, क्रेडिटर्स इंक्लूडिंग द सेंट्रल गवर्नमेंट, एनी स्टेट गवर्नमेंट और एनी लोकल अथॉरिटी to whom a debt in respect of payment of dues arising under any law for the time in force, such as authorities to whom statutory dues are owed, guarantors and other stakeholders involved in the resolution plan, ठीक है। सब पर बाइंडिंग है, गवर्नमेंट ड्यूज है उन पर भी बाइंडिंग है। सपोज जीएसटी डिपार्टमेंट के कुछ ड्यूज हैं, ठीक है, XYZ लिमिटेड इज ए कंपनी विच इज हैविंग डिपार्टमेंट ड्यूज, जीएसटी डिपार्टमेंट हैज गॉट ड्यूज इन दैट कंपनी। Now a resolution plan of XYZ Limited has been passed, whereby there is a haircut of 90% to operational creditors, including government department, ठीक है। तो जीएसटी डिपार्टमेंट वंस द रेजोल्यूशन प्लान इज पास्ड, उसके बाद में भी कैन इट रेज द डिमांड अगेंस्ट द कंपनी?
No, sir.
नो, ठीक है। तो जितने भी ड्यूज हैं, है ना, इंक्लूडिंग
Yes.
गवर्नमेंट ड्यूज, तो वो जो है it shall be binding, provided that the adjudicating authority shall, before passing an order for approval of a resolution plan under this subsection, satisfy that the resolution plan has provisions for its effective implementation। तो ये देख लेंगे भाई उसका effective implementation के लिए provision है कि नहीं। Where the adjudicating authority is satisfied that the resolution plan does not conform to the requirements referred to in subsection 1, it may by order reject the resolution plan, ठीक है। After the order of approval under subsection 1, the moratorium order passed by the adjudicating authority under section 14 shall cease to have effect, ठीक है। The resolution personnel shall forward all records relating to the conduct of the CIRP and the resolution plan to the board to be recorded on its database, ठीक है। The resolution applicant shall, pursuant to the resolution plan approved under subsection 1, obtain the necessary approval required under any law for the timing in force within a period of 1 year from the date of approval of the resolution। देखो ये जो रेजोल्यूशन एप्लीकेंट है ये बोलता है भाई रिस्ट्रक्चरिंग भी हो सकती है ना। रेजोल्यूशन प्लान में तो कुछ भी हो सकता है ना, रिस्ट्रक्चरिंग, मर्जर, एमेलगमेशन, डीमर्जर, ये सारी चीजें वो प्रपोज कर सकता है। रेजोल्यूशन एप्लीकेंट बोल सकता है भाई मेरी ये कंपनी है, आपकी दूसरी कंपनी है, मैं दोनों कंपनी को मर्ज कर दूंगा। लिस्टेड कंपनी है, मैं अनलिस्टेड बना दूंगा। कंपनी है, एलएलपी कर दूंगा, एलएलपी एक कंपनी कर दूंगा। तो इस सारी चीजों के लिए उसको अप्रूवल लेने हैं विद इन 1 ईयर फ्रॉम द डेट ऑफ अप्रूवल ऑफ द रेजोल्यूशन प्लान, और विद इन सच पीरियड एज प्रोवाइडेड फॉर इन सच लॉ विच एवर इज लेटर। ठीक है, provided that where the resolution plan contains a provision for combination as referred to in section 5। combination क्या है? combination is an arrangement which results in a monopolistic situation। ठीक है, तो अगर मोनोपोली सिचुएशन है तो उस केस में उसको प्रायर अप्रूवल लेनी पड़ेगी। ठीक है, तो ही शैल ऑब्टेन द अप्रूवल ऑफ द कंपटीशन कमीशन ऑफ इंडिया प्रायर टू द अप्रूवल ऑफ सच रेजोल्यूशन प्लान बाय द सीओसी। 32 बोलता है अपील। Any appeal from an order approving the resolution plan shall be in the manner and on the grounds laid down in subsection 3 of section 61। और 32A बोलता है liability for prior offenses। ये liability for prior offenses क्या है? देखिए, XYZ Limited is a company. Now the resolution plan has been passed. Company name remains the same unless it is changed। ठीक है, कंपनी नेम तो सेम रहेगा, मैनेजमेंट चेंज हो जाएगा सिर्फ। Now the question is whether the property, any action can be taken against the property of the company. The answer is no. Whether any action can be taken against the new promoters. The answer is no. ठीक है, the action can be taken against the promoters which were there earlier। ठीक
Yes,
है,
sir.
action can be taken against new promoters also if they are involved in fraud। ठीक है, या इन्वेस्टिगेटिंग अथॉरिटी हैज फाइल्ड अ रिपोर्ट। तो अदरवाइज it grants 32A grants immunity to the new promoters or the property of the company from any action। ठीक है, क्योंकि ये तो नया बंदा आया है ना भाई, इसको पुराने डायरेक्टर ने गड़बड़ की थी, इसने तो कुछ किया नहीं बेचारे, नहीं तो नया प्रोजेक्शन एप्लीकेंट आया, तो इसके अगेंस्ट में कोई एक्शन नहीं हो सकता, ना ही कंपनी की प्रॉपर्टी के अगेंस्ट में कोई एक्शन हो सकता। ये 32A है हमारा। ठीक है, अब इसके बाद में एक बार हम टाइमलाइंस पढ़ लेते हैं कि टाइमलाइंस क्या क्या है। ये हमारा रेगुलेशन 40A के अंदर टाइमलाइंस दे रखी है। ये है मॉडल टाइमलाइंस। ठीक है, अब सबसे पहले आप क्या करोगे? सपोज यू आर ए बैंक। ठीक है, नाउ यू वांट टू टेक एक्शन अगेंस्ट ए कंपनी। यू आर ए बैंक, you have given loan to a company has defaulted in payment, so what will be the first action you will take? सबसे पहले क्या करोगे आप?
तो सेक्शन 7 में एप्लीकेशन फाइल करेंगे।
सेक्शन 7 में एप्लीकेशन फाइल करने से पहले भी कुछ करना है क्या आपको?
जी सर, उसके लिए डिफॉल्ट का प्रूफ चाहिए, या तो इंफॉर्मेशन उटली में चाहिए या कुछ
राइट,
प्रूफ चाहिए, डिफॉल्ट का
राइट।
प्रूफ चाहिए।
या बात, या तो वहां से प्रूफ ले लेंगे, या फिर
हाँ,
कोई भी आपके पास डिफॉल्ट का कोई भी प्रूफ होगा, चेक बाउंसिंग का होगा या कुछ भी होगा, है ना।
यस
और
सर, यस
उससे
सर,
भी पहले यू विल गेट इन टच विद एन इंसॉल्वेंसी प्रोफेशनल, उससे फॉर्म 2 साइन कराओगे आप।
यस सर,
वो भी तो एप्लीकेशन के साथ उसका नाम देना है ना आपको,
जी सर,
है ना। अच्छा,
जी
सपोज
सर।
एप्लीकेशन एडमिट हो गया। एप्लीकेशन एडमिट होने के बाद में सबसे पहला काम क्या होगा?
पब्लिकेशन होगा सर उसका।
पब्लिक अनाउंसमेंट होगा। पब्लिक
पब्लिक
अनाउंसमेंट कितने
अनाउंसमेंट
पेपर के अंदर करना है?
2 पेपर में सर।
2 पेपर में। ठीक है, एंड इट हैज टू बी डन कितने दिन के अंदर करना है ये? इमीडिएटली। ठीक है, एंड इमीडिएटली मींस विद इन 3 days ऑफ द अपॉइंटमेंट ऑफ आईआरपी। ठीक है,
जी सर।
तो टी अगर हमारा कमेंसमेंट ऑफ सीआईआरपी है एंड अपॉइंटमेंट ऑफ आईआरपी है तो इट इज T+3। ठीक है, नाउ सबमिशन ऑफ क्लेम्स। सबमिशन ऑफ क्लेम्स कितने दिन के अंदर करना है? फॉर 14 days फ्रॉम द अपॉइंटमेंट ऑफ आईआरपी। ठीक है, तो 14 days में आपने सबमिशन ऑफ क्लेम्स है। उसके बाद में इन केस एनी क्लेम इज डिलेड, तो लास्ट कब तक दे सकता है वो क्लेम?
90
अप टू 90 डे ऑफ द
सर।
कमेंसमेंट। ठीक है, वेरिफिकेशन ऑफ क्लेम्स कितने दिन में करना है आपको? वेरिफिकेशन ऑफ क्लेम्स
7 days सर।
विद इन 7 days फ्रॉम द रिसीट ऑफ द क्लेम, तो मैक्सिमम कितना होगा? T+21 हो गया। अगर 90th डे को रिसीव हुआ तो T+97 हो गया। वेदर यू कैन रिजेक्ट एनी क्लेम्स एट दिस स्टेज?
यस सर।
रिजेक्ट कर सकते हो क्या?
रिजेक्ट नहीं।
the RP shall verify and collate the claims. वर्ड क्या लिखा है?
Okay.
Collate.
Collect. Yes, sir.
कोलेट का मतलब ये है कि वो दोनों इंफॉर्मेशन रखेगा, क्लेम्स सबमिटेड, क्लेम्स एडमिटेड।
Okay.
ठीक है ना? सो ही विल सीक
Yes.
इंफॉर्मेशन। अगर किसी को दिक्कत है क्रेडिटर को, तो एडजुडिकेटिंग अथॉरिटी के पास जाएगा, है ना? लिक्विडेटर हैज द राइट टू रिजेक्ट द क्लेम्स,
Yes,
बट
sir.
आरपी डजंट हैव एनी राइट टू रिजेक्ट द क्लेम्स, ही विल कीप इट पेंडिंग।
Yes, sir.
ठीक है ना?
Yes, sir.
भाई जब वो प्रूव कर देगा तो उसको सीओसी में शामिल कर लेगा, अगर वो फाइनेंशियल
Yes, sir.
क्रेडिटर है तो, है ना?
ठीक है।
एंड अर्लियर डिसीजंस विल नॉट बी अफेक्टेड। ठीक है, ये हो गया। Now application for appointment of AR. So this is to be done within 2 days of the verification of claims. और AR किन किन सिचुएशन में अपॉइंट होता है?
सर यार, एक तो रियल एस्टेट के जहाँ पर रियल एस्टेट केस में जहाँ पर डिबेंचर्स के बहुत सारे होते हैं,
एक्चुअली
डिबेंचर होल्डर।
डिबेंचर होल्डर्स और डिपॉजिट होल्डर्स, वो तो ऑथराइज रिप्रेजेंटेटिव शैल बी एज पर दी डिबेंचर ट्रस्ट डीड और डिपॉजिटर्स
यस सर।
एग्रीमेंट, है ना?
यस सर।
So here the AR concept is there for the class of creditors, usually home buyers.
ओके ओके सर।
So he will give in the public notice names of 3 ARs, name out of which one has to be selected. ठीक है? So application for appointment is within 2 days from the verification of claims received. ठीक है? Now he will give the report certifying constitution of the committee of creditors to the adjudicating authority. ये हो गया। फर्स्ट मीटिंग ऑफ सीओसी कितने दिन में करना है? फर्स्ट मीटिंग ऑफ सीओसी
7 days सर।
हाँ, विद इन 7 days ऑफ फाइलिंग द रिपोर्ट सर्टिफाइंग कॉन्स्टिट्यूशन ऑफ द सीओसी। मिनिमम कितना दिन का नोटिस देना है?
5 days सर।
5 days का। 5 days से कम भी हो सकता है क्या नोटिस? वेदर इट कैन बी रिड्यूस्ड?
यस सर, विद सीओसी परमिशन।
राइट, हाँ, ठीक है। लेकिन मिनिमम कितना होगा फिर भी?
48 hours सर।
हाँ, मिनिमम उसमें लिखा हुआ है, ये जो है not less than 24 hours. The committee may reduce the notice period from 5 days to such other period of not less than 24 hours as it deems fit. और 48 hours होगा in case there is an AR. ठीक है, तो ये ध्यान रखना। Now resolution to appoint RP by the COC. So in the first meeting the COC shall appoint the RP. ठीक है, और इसके लिए परसेंटेज कितना है? रेजोल्यूशन फॉर
66%
अपॉइंटमेंट ऑफ आरपी
66% सर।
बिल्कुल ठीक है। चलिए, उसके बाद में अपॉइंटमेंट ऑफ आरपी हो गया ऑन अप्रूवल ऑफ द ए। सो इफ दे आस्क यू क्वेश्चन हु इज द अपॉइंटिंग अथॉरिटी फॉर आरपी, तो अपॉइंटिंग अथॉरिटी कौन है?
आईबीबीआई सर।
अपॉइंटिंग अथॉरिटी इज एडजुडिकेटिंग अथॉरिटी, नॉट आईबीबीआई।
ओके।
एडजुडिकेटिंग अथॉरिटी है, ठीक है ना? COC gives its recommendation with 66% majority, but the AA is the appointing authority. और कोई भी प्रॉब्लम हो वो AA से ही पूछना है इसको। मान लीजिए इसकी कोई सर्जरी ड्यू है, he wants some leave etc., तो एडजुडिकेटिंग अथॉरिटी को अप्रोच करेगा। अपॉइंटमेंट हो गया। IRP perform the functions of RP till the RP is appointed. If RP is not appointed by 40th day, ठीक है, appointment of valuers has to be done within 7 days of the appointment of RP, but not later than 47th day of the commencement. ठीक है, ये भी हो गया। सबमिशन ऑफ एप्लीकेशन फॉर विड्रॉल, ठीक है, बिफोर एक्सप्रेशन ऑफ इश्यू ऑफ एक्सप्रेशन ऑफ इंटरेस्ट, ठीक है, या विद इन 7 days ऑफ इट्स रिसीट और 7 days ऑफ कॉन्स्टिट्यूशन ऑफ द COC विच COC टू डिस्पोज ऑफ द एप्लीकेशन। सो एप्लीकेशन फॉर विड्रॉल has to be given by the applicant only. Now there could be two situations. It could be before the constitution of the COC, then it can be withdrawn by the applicant only. And if COC is formed, then COC can pass the resolution with 90%.
90%।
ठीक है, तो filing application for withdrawal if approved by COC with 90% majority voting by RP to A. ठीक है, and there is a time period also within 3 days of the approval by COC. Now there is a timeline for this avoidance transactions also. Suppose some preferential transaction is there, or some undervalued, extortionate or fraudulent transaction is there. So within 75 days, he has to form an opinion on the preferential and other transactions. भाई कोई पैसी transaction हुई है कि नहीं, तो 75 days. In 115 days, he has to make a determination, and in 130 days, he has to file an application. Submission of information memorandum to COC कितने दिन में करना है? Within 95 days.
95.
Publication of Form G कितने दिन में होना है? Within 60 days. ठीक है. Submission of expression of interest at least 15 days from the issue of expression of interest minimum. ठीक है. Provisional list कितने दिन में बनानी है? Within 10 days from the last date of receipt of EOI. Submission of objections कितने दिन में हो सकता है? For 5 days from the date of the provisional list. ठीक है. फिर final list of resolution applicants by RP within 10 days of the receipt of objections. Issue of request for resolution plan including evaluation metrics within 5 days of the issue of the provisional list T+105. Receipt of resolution plans कम से कम 30 days, at least 30 days from the issue of RFRP. ठीक है. तो T+135. Submission of COC approved resolution plan to the adjudicating authority as soon as approved by the COC. ठीक है ना. But at least 15 days before the last date of this CIRP T+165 and approval of resolution plan by A T+180. तो ये पूरी टाइमलाइन है which has to be prepared according to 180 days. 180 days is given in section 12. Now filing of forms. The insolvency professional, IRP or RP as the case may be, shall file the forms along with the enclosures thereto on an electronic platform of the board as per the timeline stipulated against each form. जो प्री असाइनमेंट के लिए फॉर्म IP1 है, तो ये कब फाइल करना है? दिस इंक्लूड्स consent to accept assignment as IRP or RP, the details of the IP and the applicant, the details of the person which will undergo the process, terms of consent, terms of engagement. ठीक है. IP को फाइल करना है within 3 days of signing of Form 2. ठीक है. और Form AA as the case may be. CIRP 1 कब फाइल करना है? From commencement of CIRP till issue of public announcement. इसमें क्या रहेगा? डिटेल्स ऑफ पब्लिक अनाउंसमेंट, डिटेल्स ऑफ IRP, CD एंड द एप्लीकेंट. तो ये आपको फाइल करना है विद इन 7 days ऑफ मेकिंग द पब्लिक अनाउंसमेंट. फिर CIRP 2 का फाइल करना है फ्रॉम पब्लिक अनाउंसमेंट टिल द कंफर्मेशन और रिप्लेसमेंट ऑफ IRP. तो दिस हैज टू बी डन विद इन 7 days ऑफ द कंफर्मेशन और रिप्लेसमेंट. CIRP 2. CIRP 3 क्या है? फ्रॉम अपॉइंटमेंट ऑफ RP टिल इश्यू ऑफ इंफॉर्मेशन मेमोरेंडम. CIRP 4 from issue of information memorandum till issue of RFRP. सारी टाइमलाइंस है इसके. From issue of RFRP till completion of CIRP. CIRP 5 फाइल करना आपको. फिर CIRP 6 क्या है? ये इवेंट स्पेसिफिक है. ठीक है. सपोज यू आर फाइलिंग एन एप्लीकेशन फॉर PUFE ट्रांजेक्शंस, तो विद इन 7 days ऑफ द occurrence ऑफ द रेलेवेंट इवेंट आपको फाइल करना है. इफ यू आर रेजिंग इंटरिम फाइनेंस, तो भी आपको within 7 days of the raising of interim finance. Commencement of insolvency resolution process of guarantors of the CD, ये भी आपको फाइल करना. Extension of period of CIRP and exclusion of time, premature closure, request for liquidation, non implementation of resolution plan. तो ये CIRP 6 आपको फाइल करना है. ठीक है. ये सारी टाइमलाइंस अगर दे रखी है, सपोज एनी एक्टिविटी इज नॉट कंप्लीटेड, तो फिर आपको CIRP 7 फाइल करना. ठीक है. Within 3 days of the set date. Suppose public announcement is to be made within 3 days and it was not made within 3 days. तो ये एग्जाम्पल दे रखा है. ठीक है. से पब्लिक अनाउंसमेंट इज नॉट मेड बाय T+3rd day. तो क्या करना है आपको? टाइमलाइन कितना है? यू हैव टू फाइल इट विद इन X+30th day. और फिर every 30th day you have to go on filing till that activity is incomplete, until the said activity remains incomplete. ठीक है. एग्जाम्पल भी दिया गया. If the public announcement is not made by T+3rd day, ठीक है ना, form CIRP shall be filed by T+6th day. Thereafter, if public announcement is made on T+16th day, no further form CIRP will be filed. However, the public announcement is not made till T plus 33rd day. तो फिर फॉर्म CIRP shall be filed on T plus 36th day. ठीक है, क्लियर? ये सारे फॉर्म्स के बारे में. एक केस स्टडी भी मैंने शेयर किया था आपसे. वो केस स्टडी देखा था वीरेंद्र परिहार जी?
कौन सा सर?
वो केस स्टडी एक दिया था ना मैंने आपको. ये ग्रुप पे डाला था कि नहीं डाला था, मेरे ख्याल तो देखता हूँ, नहीं तो मैं शेयर कर दूंगा आपसे.
जी सर.
एक बार आप देख लीजिएगा. जस्ट अ मिनट. ये केस स्टडी शेयर किया था कि नहीं?
नहीं किया सर.
नहीं सर, ये नहीं किया सर.
ओके ओके. तो आई शेयर दिस केस स्टडी, तो प्लीज गो थ्रू दिस केस स्टडी, है ना?
यस सर. ओके
इसको
सर.
करके देन आई शेयर द रिकॉर्डिंग ऑल्सो. वी हैव डिस्कस्ड दिस केस स्टडी ऑल्सो. तो लेकिन पहले आप खुद पढ़ लीजिएगा, देन आई शेयर द रिकॉर्डिंग ऑल्सो फॉर दिस,
ओके सर.
है ना?
ओ,
तो काफी डिटेल में है ये केस स्टडी, सो यू कैन गो थ्रू दिस केस स्टडी. ये फिर एक और दूसरी केस स्टडी है. देयर आर 2 केस स्टडीज इन दिस, सो यू कैन गो थ्रू दिस केस स्टडीज. ठीक है, तो विल स्टॉप हियर टुडे.
यस सर.
Sir, Chandrasekhar speaking, sir.
यस प्लीज.
Sir, while going through section 30, sir, you were telling that the resolution applicant would provide some details of payments, distribution of payment, inter alia, stating that he is bound to pay the minimum liquidation value to the operational creditor.
Right.
OCs.
Right.
So how will he know that he is paying the liquidation value? He is not
Actually,
paying.
I already explained it to you. Actually, the RP shall appoint 2 registered valuers within 7 days and maximum within 47 days of the insolvency commencement date. So they will provide him the fair
Sir,
value and
sir,
liquidation value.
I'm not on that point, sir. I'm not on that point.
हाँ.
The resolution applicant will submit the details of payment, including CRP, etc., etc.
Right.
But how will we know that he's complying with the
No. The point is
payment
that
liquidation value to the
the
OC?
point is that resolution applicant should not offer too low an amount. He will not know the liquidation value.
Okay.
RP will not tell him.
Okay.
But actually, based on the information memorandum, because he is being given all the details of the properties,
Yes, sir.
location of properties in their condition,
sir.
etc. So he
Yes, sir.
can make an estimate that at least the idea is that he should give the maximum value.
Okay. One more thing, sir.
Yes.
Suppose his plan is rejected on the ground that liquidation value to OCs is not given, but will he get a chance to improve his offer?
No, in the COC normally, that is why we have read this provision that the resolution applicant can attend the meeting in which his resolution plan is being discussed. So he may improve on the plan.
The negotiation chance is there. It is not
Yes.
that outright case will be rejected. It's not that way.
Yes. So
Sir, one more.
Yes.
Sir, one more thing, sir. I attended the morning session also. I could not attend properly because I will be traveling all the time.
Okay.
So in that thing, I wanted to ask you one thing. I didn't get a chance to ask you. Sir, here, if we see that section 30 contemplates compliance of certain things in terms of distribution, as mentioned in section 53.
Right.
Section 52 is a different chapter or a different part, but is
Yes.
it applicable to part 2 and this chapter, sir, the CRP chapter?
Actually, the point here is that section 53 acts as a yardstick. So
Okay.
section 53 is not being applied here.
The
But
basic guideline, basic
yes, it
guideline.
is a guideline that
Okay.
okay, at least that much is ensured.
Okay.
So the point, it is a visualization.
Okay.
It is a visualization of section 53
Right,
that
sir.
had liquidation been occurred, had liquidation been the scenario, then what they would have got.
Okay.
In
Okay.
that situation, what the operational creditors or dissenting financial creditors would have got. So it is basically a visualization of that scenario. That
Okay.
liquidation is not taking place here.
Right, sir. Right, sir. Only the manner of distribution should be in that manner. It should be the plan should be in compliance of that 1 to 3
Right,
steps provided.
right. Because he has got the liquidation value. RP knows the liquidation value.
Yes,
So he
sir.
knows that if liquidation occurs, then what everyone will get. So
Okay.
he will check whether the RP is giving that much amount. That is the idea.
Sir, last question, sir.
Yes, please.
Sir, just now you were scrolling through the timelines, 40A, 40,
Yes.
things like
Uh-huh.
in that one tabular column was there that the plan shall be submitted. The code, it is 180 days time is there. But if for any reason by 165th day, if he is not able to submit the plan, or if COC is not able to approve the plan by 165th day, then what will happen to the exercise?
No, no. They will approach, they will pass a resolution for extension. They will apply to the adjudicating authority for extension of 90 days.
Okay, these timelines are not sacrosanct.
These timelines are directory only. The Supreme Court has
Okay.
time and again said that all these timelines are directory in nature, not mandatory.
Okay, sir. Okay.
So there is
Okay.
always an overrun of all of these timelines.
So I have all the time I see
Endeavor has to be made to uh, follow these timelines to the extent possible. And if there is any delay, then he has to file the forms. That forms also we have seen. If there is any delay, every day of delay has to be satisfactorily accounted for, and then the certain forms have to be filled up in case of any delay. Yes, please.
right, sir. But sir, the last word, sir. I have a lot
Yes.
of appreciation for your patience to explain the people, because the kind of freshness I see in the morning, also I see the same freshness and agile to explain to the students. Thank you very much for your patience in explaining the students, because morning at 8 o'clock, 8:15, 8:30, I see you, the same freshness in your face and your tone. Extremely delightful to have such a teacher for this thing.
I'm
Unfortunately,
always available for you.
yeah,
I will allow you in the evening batch also because I know you are not able to attend. You have
yes,
got
sir.
access to recordings also, and you
Yes, sir.
can ask me questions on phone also. No issue. So
Yes,
if I'm free, I'll be too pleased to offer.
Yes, sir. I would like to tell you one thing, sir. Today I went to the Airtel shop and that fellow has restored the WhatsApp. Therefore, I could see your message at 8:10, immediately logged in. I was at home
Okay,
only.
okay,
Yeah.
great, great,
Thank you, sir. Thank you
great.
so much,
Thank you.
sir.
So now your WhatsApp is okay.
WhatsApp is restored, sir. I don't know till what time, because normally, sir, with one chat, it was getting disrupted. But since afternoon time, I'm able to chat continuously. It is well, sir. It is good, sir.
Okay, okay.
Morning, I will join, sir. I may not be able to interact. I will listen to the case along.
No issues. No
Morning
issues.
session, I'll be listening. I'll be trying, sir. Half-heartedly, I'll be listening to it. But videos I'm continuously going through, sir.
Okay, okay, okay. Thank you
Thank
so
you
much.
very much, sir. Good night, sir.
Okay, good night.